There seems to be quite a lot of dreams coming true happening today. In April 2015, I got the dreaded phone call from Cape Town. Robin wants to see you. And I flew down to Cape Town to say goodbye to our beloved advocate. And we were heartbroken. We didn't know where the case would go. We didn't know what the future was after all our hard work. And then there was a ray of sunshine, because everything comes together in the end. Schindler's attorneys recommended a certain advocate, Don Mahon. We'd never heard of the man. We didn't know whether he would understand our case, because after all, he would be the person that would steer our ship. So we said, okay, let's meet. We're quite used to meeting with these legal beagles. So we put on our best interview clothes, got the lipstick on, best behavior, and off we went to Maisel's chambers in Sandton. Well, I can tell you with all certainty in my mind and in my heart that it was the best thing ever. From the minute that we met Advocate Mahon to watching him at work in the court this last week, we knew that this was the right person for the job. Ladies and gentlemen, please give a round of applause for our captain of our ship, Don Mahon.
Good afternoon. When I was initially asked to give a talk on cannabis, I wasn't sure whether I was being asked to talk about cannabis or whether I should be on cannabis and give a talk. Well, my speech today is not about cannabis, so you can decide for yourself what that means. No, today I'm not talking about cannabis, and today I'm not talking about the trial of the plant. I'm talking about public interest law. But first, before I even get onto public interest law, I'd like to start with a story that features in a series of lectures given by a political philosophy lecturer at Harvard, Michael Sandel. Suppose you're the driver of a tram, or a trolley car as it's sometimes called, which is hurtling down the track at 100 kilometers per hour. At the end of the track, you notice that there are 5 workers working on the track. You try to stop, but you can't. Your brakes have failed. And you feel desperate, because you know that if you crash into these 5 workers, you will surely kill them. But then you notice that off to the right, there's a side track. And at the end of that track, there's 1 worker. And your steering wheel works. So you could turn the steering wheel and move the tram onto the side track, killing the 1 worker, but sparing the 5. What would you do? I'd like to find out from the people in the crowd. How many people would turn right, turn onto the side track, by show of hands? How many would carry on along the track? Okay. The clear majority would turn onto the side track. So let's investigate the reason for that. I would think that the obvious reason is that most would say it's better to kill 1 person instead of 5. Or kill 1 so that 5 can be spared, right? Seems obvious. But let's test that principle. This time, let's suppose that you're not driving the tram, you're an onlooker, standing on a bridge, looking at the tram hurtling down the track at 100 kilometers an hour, and at the end of the track there are the 5 workers. The brakes don't work, and the trolley car or the tram is about to careen into the 5, killing them all. But then you notice, standing next to you on the bridge, leaning over, is a very fat man. You could give him a shove. He'd fall onto the track in front of the trolley car. He would die, sparing the 5. So, let's see. How many of you would push the man onto the track? Show of hands. How many wouldn't push the man onto the track? Show of hands. So here's the obvious question. What became of the principle? Better to save 5 lives by sacrificing 1. A principle that, by far, the majority endorsed in the first scenario that I gave. How do we reconcile the reaction of the majority in these 2 cases? What is the difference? On the one hand, you are deliberately turning the steering wheel, knowing that someone will die. In the second case, you are deliberately pushing someone. Let me ask you this. Would it have made a difference to your answer if, instead of pushing the fat man off the bridge, he were standing over a trap door, and to open the trap door, all you had to do was turn the steering wheel? Would it have made any difference? How about a different case? Imagine you're a doctor, as most or some of you are. Imagine you're a doctor in an emergency room and 6 patients come to you. They've been in a terrible tram wreck. Five of them have sustained moderate injuries, and 1 of them has sustained severe injuries. You could spend the whole day caring for the 1, but the 5 would die. Or you could attend to the 5, and the 1 severely injured would die. So, show of hands. How many would save the 5? How many would save the 1? So, the majority would save the 5. I assume it's the same reason. 1 life versus 5. Let's consider another doctor case. Now, you're a transplant surgeon, and you have 5 patients, each in urgent need of an organ transplant to survive. 1 needs a heart, 1 a lung, 1 a kidney, 1 a liver, and 1 a pancreas. And you have no organ donors. You're about to see them die, and then it occurs to you, in the next room, there's a healthy guy who came in for a checkup. Just so happens, he's busy taking a nap. You could go in very quietly, yank out the organs. That person would die and you could save the 5. So who would do it? Who would kill the 1? Anyone? Any takers? Of course not. We know that you wouldn't do that because that would be murder. So what do we make of this? Let's step back. There are certain moral principles which have begun to emerge from this discussion. The first is the notion that the right thing to do depends on the consequences which will flow from your action. Better that 5 should live even if 1 must die. That is called consequentialist moral reasoning. What is right depends on the consequences of your actions. Then we looked at the other cases and people weren't so sure. The reasons given by most people are related to the intrinsic quality of the act itself. Whatever the consequences, people think it is categorically wrong to kill an innocent person, even to save the lives of 5 other people. This is called categorical moral reasoning. The notion that some acts are simply categorically wrong. The most influential example of consequential moral reasoning is utilitarianism. It's a doctrine invented by Jeremy Bentham, an 18th century English political philosopher. And the most important example of categorical moral reasoning is the 18th century German philosopher Immanuel Kant. Bentham's philosophy, in essence, was that the right thing to do, the just thing to do, is to maximize utility, meaning the balance of pleasure over pain, happiness over suffering, that the right thing to do, either individually or collectively, is to act in a way that maximizes the overall level of happiness, the greatest good for the greatest number. So let's test that theory with reference to another story. But this time not a hypothetical story, but a true story. One that is well known to most students of law. The case of the Queen versus Dudley and Stevens. This is, as I say, a true story of events which took place in May of 1884 and which ended up in a much publicized trial in England. The English yacht, the Mignonette, set sail on around about the 19th of May 1884 with a crew of 4 people. Tom Dudley, the captain, Edwin Stevens, Edmund Brooks, and one other, a cabin boy by the name of Richard Parker. Richard Parker, 17 years old, an orphan, no family, and an inexperienced seaman. On the 5th of July, whilst at sea, a wave struck the yacht and washed away the bulwark. The Mignonette sank within 5 minutes of being struck, and the crew abandoned ship for a lifeboat, managing only to salvage vital navigational equipment, along with 2 tins of turnips and no fresh water. They were out at sea for a number of days. They managed to sustain themselves on the 2 tins of turnips and fortuitously being able to catch a sea turtle, but were largely unsuccessful in catching any rainwater, with the result that Parker, the youngest, the cabin boy, started to drink the seawater and became ill. It was at this point that discussions ensued about the prospect of sacrificing one of the members on the lifeboat, killing him to provide for food and so that they could drink his blood. The initial discussions centered around the proposal of a lottery system in order to decide who the unlucky person would be. But that proposal was never resolved. Ultimately, Parker, the cabin boy, fell into a coma. And so the discussions between Dudley and Stevens were to the effect that, look, it's unfortunate that someone has to die. Parker's probably going to die anyway. He doesn't have any family or friends. He won't be missed. We, on the other hand, have families, we have children. Let's resolve to sacrifice the cabin boy Parker for the greater good. And so, Dudley said a prayer, and with Stephen standing by to hold the youth's legs if he struggled, Dudley pushed the penknife that he had into Parker's jugular vein, killing him. A few days later, they were rescued. Upon arriving home, they didn't try and hide their conduct. In fact, they were quite forthright in making statements to the police because they felt confident that, given the circumstances, they would never have been prosecuted. They acted surely out of sheer desperation. So, if you were the jury, would you convict? Send them to jail? How many would send them to jail? How many would acquit them, set them free? Well, there's a majority, but it's certainly not a large majority. I can tell you that the court convicted them, sentenced them to death with a request for clemency, and they were ultimately granted clemency. But these examples, some more abstract and some more absurd than others, illustrate some of the tough decisions that judges have to make from time to time. Fortunately, in our case, our courts will always look for guidance in the Constitution. You heard Paul Michael. Our Constitution is revered around the world. It's studied as an example of progressive liberal jurisprudence. It is almost a sacred document in our country, guaranteeing the rights of each of us. The Constitution informs the balancing of competing interests which so often form the subject matter of judicial debate. The beauty is that those protections are afforded to each of us equally and can be enforced not only by individuals on their own behalves, but generally in the public interest. That means that people can go to court to protect your rights, even if you're not involved. Broadly, public interest is defined as the welfare or well-being of the general public. More narrowly, public interest law is a term that became widely adopted in the United States, built on a tradition exemplified by Louis Brandeis, who, before becoming a US Supreme Court justice, incorporated advocacy for the interests of the general public into his legal practice. He said, and I quote, "Able lawyers have to a large extent allowed themselves to become adjuncts of great corporations and have neglected their obligation to use their powers for the protection of the people." And so, public interest litigation is a means to afford protection to those who are vulnerable, those whose rights are under threat. Our Constitution guarantees us the protections of the Bill of Rights. Now, South Africa in particular has made significant strides in improving access to justice for its citizens. Unfortunately, factors such as poverty, lack of education, lack of resources, all continue to hinder the government from delivering on this constitutional right of access to justice. One thinks of the working conditions of many of our judicial officers, which include poor and inadequate support services, lack of chambers for judges, and insufficient courtrooms. The difficulties for the recipients of justice, especially the poor, are more desperate. because unlike judicial officers, they are powerless and usually cannot solve the conditions in which they find themselves. Poverty is another impediment to the access of justice for a huge number of people in our country. Many people do not know the law, do not exercise their rights due to poverty-related lack of education and ignorance. There is also a need for citizen education about the justice system so that people know their basic rights, the different courts and structures which they could turn to when they have problems. Access to justice is also hindered by language, where cases are lost simply because of an incorrect interpretation by the interpreter. Also, lack of transport. Cases are thrown out because people can't make it to court. Our former Chief Justice, Sandile Ngobo, addressing an Access to Justice conference in 2011, referred to 8 basic principles of a civil justice system. These were: it should be just in the results it delivers. It should be fair and be seen to be fair. Procedures and costs should be proportionate to the nature of the issues involved. It should deal with cases with reasonable speed. It should be understandable to those who use it. It should be responsive to the needs of those who use it. It should provide as much certainty as the nature of a particular cause allows. And it should be effective, adequately resourced, and organized so as to give effect to all of those principles. One of the consequences of our unfortunate history is that it did birth a number of admirable public interest lawyers. One of those, Vernon Barange, lead counsel for the defense in the treason trial, audaciously took the battle onto apartheid territory. And many parallels can be drawn with between many public interest cases. And he announced in that case that what is on trial here are not just 156 individuals, but the ideas which they and thousands of others in our land have openly espoused and expressed. 20 years after the start of the treason trial, public interest lawyers continued to embrace the same strategies to counter apartheid. At Wits University, John Dugard established the Center for Applied Legal Studies, which created an academic base for practitioners to attack apartheid while seeking to pave the way for a more just legal system. Felicia Kentridge and Arthur Chaskelson were amongst those who founded the Legal Resources Center in 1979, a pioneering firm of public interest lawyers. And it was stated by the eminent Justice O'Regan in our Constitutional Court. She pointed out how litigation in this area is designed to hold the democratic arms of government to account. This kind of litigation, she said, fosters a form participative democracy that holds government accountable and requires it to account between elections over specific aspects of government policy. This is because when challenged on its policies, the government agency is obliged to explain why the policy is reasonable. Government must, she pointed out, disclose what it has done to formulate the policy, its investigation and research, the alternatives considered, and the reasons why the option underlying the policy was selected. One can draw parallels, as I say, with many cases. But the theme is a recurring one. Our Constitution has enabled us as lawyers to protect those who require our protection and to attack the laws and conduct which violate the Constitution. It makes us a better country. It makes us a country where same-sex couples can tell the government that they deserve equal protection before the law. It makes us a country where persons with HIV can take on big corporations who discriminate against them. It makes us a country where the courts can tell the most powerful man in this land to pay back the money. The Constitution gives us the gift, whether black, white, rich, or poor, of not having to be content to have our destinies written for us, but to choose to have them written by us.
Thank you very much. Thank you very much, Don. Thank you for clarifying all those legal issues.